let's talk about the Americans for Prosperity versus Bonta. This, if the words of Anthony Kennedy in Citizens United echo in my head over and over again. Well, it's something to the effect of, at least we have disclosure. If we didn't have disclosure, there would be a problem with this corporate money. And here we are.
Yes. So this is a case about donor disclosures in California, specifically people who give a ton of money to charities, including partisan political charities. So the plaintiff here was Americans for Prosperity, which is a Koch-run charity, right? But they're registered as a nonprofit in California. California passed this law that requires charities to turn over the names of their very high dollar donors to the state attorney general. The state attorney general uses that information to prevent charitable fraud. A quarter of all charities are located in California in this country. Charitable fraud is a real and serious problem, and it often takes the form of charities promising donors one thing and then doing something totally different with their money. So the idea here was, well, the attorney general is going to follow up with donors, make sure that the money is actually being used for what it's being promised for. The Supreme Court strikes down that entire law on its face, not just as applied to charities that face serious threats of retaliation to their donors, but every single charity, and says this violates the First Amendment freedom of association, which, by the way, is not really in the First Amendment. It's a sort of penumbra you have to find. If you gaze deeply into the First Amendment, you can extract this freedom of association. The Chief Justice said people will be too scared to give money because they don't want their names turned over to the California Attorney General. People will decline to associate with these organizations. So the court has to subject any kind of disclosure law to something that looks a lot like strict scrutiny, really heightened, intense judicial scrutiny. And Roberts, in his majority opinion, said this law doesn't pass it because basically there's no evidence that California is going to use the information correctly, and the law is not sufficiently tailored to address the needs that the state has put forward. Which, to translate all that, as Sotomayor put it in dissent, the court has put a huge bullseye on all disclosure laws, specifically including election and campaign finance disclosure laws, which is what this case is really about if you read between the lines.
How can they, well, so what is the standard for the strict scrutiny as it's applied here? And how can they say it doesn't reach that, it doesn't pass that threshold, considering that was almost like the leverage point for allowing unlimited corporate donations in the first place?
Right, exactly. That was the theory behind Citizens United, and the court upheld disclosures there by an 8-1 vote and said, don't worry, we're all good with disclosure laws. But here, the court turns around and jacks up the standard. And what's key, the move here to understand, is that the court says any kind of disclosure law has to be subject to narrow tailoring. So it has to be as narrowly tailored as possible to satisfy the government's important interests in whatever it's trying to achieve. Narrow tailoring is a really strict test because you can always fly spec the government's justification for a law and say, well, you could have made this even narrower. You could have excluded more groups. You could have set a higher threshold. You could have done all this stuff that you didn't do, and so we don't think this satisfies strict scrutiny. And that is a new rule, because in the old days, it used to be that you would only get to that level of scrutiny if the individual fighting the disclosure rule had proved that they were facing actual harm, that people were harassing them for their free association, that people were threatening them with violence. Only then could you get a foot in the door. What Roberts did is get rid of that threshold requirement that you prove you're actually facing retaliation or harassment, and say anyone who doesn't want to disclose information to the government, all you have to do is raise a challenge to a law on its face, say it's not narrowly tailored, and in short, you will win.
I mean, this seems to just, it seems to have potential implications even beyond the disclosures that come with contributing to political organizations, to political, I mean, like, the government requires some information from you that ends up being, somewhat public, right? I mean,
right.
like, this seems to, in some ways, again, another assault on sort of government's ability to regulate, just through
Absolutely.
another direction.
Absolutely. So you can imagine, say, a business telling the government, we don't want to turn over our worker pay. We don't want to disclose that information to you because we think we'll leak it. And other businesses will seize upon it to either provide more competitive pay or cut costs or whatever. And as soon as a business raises that challenge, in theory, the government's going to have to prove that this regular, boring, vanilla regulation that's probably been on the books for decades satisfies this super strict standard of review. But I do think that right now, what Roberts is setting his sights on are these campaign finance laws that require disclosure of people who've donated money to a candidate or a campaign, because this opinion really just tees up a future decision where the court will say, you know, we don't think that a requirement of disclosures for donors who gave over $1,000 satisfies this heightened scrutiny, because $1,000 isn't that much. And the government hasn't proven that $1,000 can corrupt any candidate. And without that evidence, we're going to strike this down. The next case, $5,000, the next case, $25,000. At some point, the court basically just rules out the possibility of disclosure laws altogether.
And I mean, and I know this is tangential, but you know, the way they work is they're teeing up stuff that may be reversed, you know, 3, 4, 5 years down the road. Like in New York City, I imagine they have it in other places. You know, the Board of Health gives a grade on how clean your restaurant is. I mean, it seems to me like, well, you disclose that to the public, it could hurt our business. I mean, it's one thing for the Board of Health to come in and say, here's a grade, you've got to raise it. But I mean, do you really need to tell the public?
Right. And one thing that's important to note here, and we talked about this in the context of Cedar Point, the union case, right? It's not just about these particular facts, and it's not just about precisely what's required and what's not. It's about making regulation so burdensome and so expensive for the government that the government just gives up. The government does not have an army of lawyers like many of these businesses and politicians who are willing to defend their interests for, you know, ever. The government doesn't have an endless army of lobbyists or an endless amount of resources to fight this battle. It is a David versus Goliath kind of battle. And at the end of the day, I think your example is a good one. There's a good chance that the government will just give up rather than trying to protect these disclosure rules. And that is maybe what I'm most afraid of here. Not just that the government will keep losing in court, but that the government will stop trying because it can't afford to keep fighting these battles at all.
Folks, there's more of what you've just saw where that came from. That's if you hit the subscribe and like button. Thank you. Really, thank you.